to all of you who are joining. We are really happy to have you for this webinar organized by the Ciarb Nigeria branch. My name is Sylvie Beboye Bongo. I'm a Cameroon national, a dispute resolution lawyer, arbitrator, and practicing both in Africa and Europe. We are really happy to be there today for our webinar. Let me first of all thank the Ciarb Nigeria branch who kindly organized this webinar. It's a great pleasure, honor, privilege for me to be part of this webinar on this very keen and important topic about understanding the OHADA arbitration system, opportunities and insight for Ciarb members. As an introduction to this webinar, let me first of all thank my lovely sister, Sola Agdebomi, and our team who made this possible. Mr. Sola is a true Pan-Africanist lawyer, and I salute our leadership in our region for the development of arbitration and ADR. Since I've been involved in this field, I've met Sola in so many events, and I can see a commitment through all this year. And regardless of each party of Africa, Sola is always there. And I wanted sincerely to thank her for being at the initiative of the organization of this webinar. I will always, and I will also want to remind why this webinar has been organized. It was during the ICACIA conference that I observed that during the different speech we had, and where we were really trying to push African cities as African seat for arbitration, none of the Francophone Africa city was mentioned. So I went to see Shola and said to her, this cannot be possible. How can we want to enhance and talk about arbitration in Africa without mentioning or ignoring some parties of Africa? Can we really be honest to ourselves if we don't speak about OHADA and OHADA arbitration today? And the response of Sola was so nice and simple. She said, oh, Sylvie, you know, sometimes people don't just know what their neighbor are. And she said, I'm now the head of the Ciarb Nigeria branch, and I would like you also organize a seminar whose title would be Understanding Our Neighbors. And we are there today to try to make you understand what OHADA is, what is OHADA arbitration is about. And I'm really, really happy because we are lucky to have an outstanding panel. I'm really thankful to have the panel I have today, because as you know, it is very difficult to have some people. So the purpose of today, the objective of today really is to help you understanding better, because I know most of you have heard about OHADA. You have heard about OHADA arbitration, but our task today is to make you understand better what arbitration is and what arbitration, OHADA arbitration is about, and what are the opportunities for our neighbors. So for this task, as I was saying, I have an outstanding panel of practitioners. The fact to invite, because our time is limited, is Dr. Kenfak Duashni. Really, I was saying a minute ago that it's very, very difficult to have some people, and I'm I am thankful to have him really today because he's our father, is our pioneer, is our elder in this in our area. Dr. Kenfak is one of these people you don't need to introduce. You don't need any introduction. So I will just say a few words about him. He's a senior magistrate in Cameroon. I don't know how to say magistrat or hierarchy in English. Maybe Julius will explain, but he's a very
super scale magistrate.
Okay, he's a first scale magistrate. He's a full professor of law, and is the current president of the African Association, Arbitration Association, who will having his annual conference in some days in Cairo. He's also the president of the APA, which is the the Association for the Promotion of Arbitration in Africa. Has been the president of UNCITRAL. He has so many heads in his head, so he don't need introduction, and is one, as I was saying, one of the pioneer of OHADA. So I'm really happy to have him with us, and without further process and without delay, I would give the floor to Dr. Kenfak to try in 15 minutes to explain first what is OHADA, and to explain what is OHADA arbitration is about. You will have understood that I will introduce my panelists when they will be taking the floor. So Dr. Kenfak, the floor is yours to try to explain us really in 15 minutes what is OHADA and what is OHADA arbitration system is about. Thank you.
Can you hear me?
Perfectly. I
Yes,
think also
we can hear you.
The participant can confirm.
Thank you, Sylvie, for introducing me, and I will humbly join my voice to yours in thanking our sister and friend Shola for making this possible. Yes, despite the evidence, one can realize that law, arbitration law, together with the CCJA rules of arbitration, accountancy law, carriage of goods law, cooperative law, mediation law, and non-governmental organization accounting law. As you can see, arbitration is one of the areas covered by the OHADA Treaty. And OHADA arbitration is governed by two bodies of rules, the Uniform Act on Arbitration and the Common Court of Justice and Arbitration Rules of Arbitration, respectively UUA, UAA, and CCJA Rules of Arbitration. The previous arbitration rules were adopted on March 1999 in Ouagadougou, Burkina Faso, and they were modified on the 23rd November 2017 in Conakry to take into consideration the evolution registered in international arbitration since 1999. Now, based, amongst others, on the UNCITRAL arbitration rules, the Uniform Act on Arbitration is the arbitration law in the OHADA contracting states. It incorporates some New York Convention provision rules, significant principle from the French arbitration law. It makes no difference between domestic and international arbitration, so including the flexibility that characterizes international arbitration. The Uniform Act on Arbitration governs both ad hoc and institutional arbitration. It foresees that the arbitral tribunal shall be composed of a sole arbitrator or of three arbitrators. And according to this text, during its mission, the arbitral tribunal must ensure that the parties are treated equally and that each party has given full opportunity to present its case. And when composed of 3 arbitrators, the tribunal shall issue the award unanimously or by a majority. Dissenting opinions are permissible here, but do not invalidate the award. The parties may also reach an arbitral award by consent. So, as indicated, the original version of the Uniform Act on Arbitration was adopted on 11 March 1999, and the modification of this text took place on 23 November 2077 to include investment arbitration in its scope of application, together with some other provisions to make the text closer to the UNCITRAL arbitration rules and more efficient. This new version includes some new provisions indicating, for example, the deadlines within which the state courts must render their decision when interfering in the arbitration process, be it in order to help putting in place an ad hoc arbitral tribunal for the delivery of exequatur in view of the first full execution of an award, or to precise the deadline in which a state court sets for the setting aside of the award must render its decision. The principles that characterize international arbitration are so present in the Uniform Act on Arbitration. So, based on the UNCITRAL rules of arbitration, the Uniform Act on Arbitration is consistent with the international arbitration trends. Therefore, it's a modern text. And the CCJA arbitration rules are all equally modern. To that effect, let me recall that the Common Court of Justice and Arbitration is the Supreme Court of the 17 OHADA contracting state for OHADA business law. And as I have already indicated, it's also an international center of arbitration which manages arbitration according to its rules of arbitration that are inspired by the ICC rules of arbitration. And in the CCJA rules, the arbitral tribunal may also consist of 1 or 2 arbitrators, and upon receipt of the case file, the arbitral tribunal must call the parties to a meeting within 45 days to draft a procedural report, which is a document that is the equivalent of the ICC arbitration terms of reference. I also indicate here that the first version of the CCJA rules of arbitration was adopted on 11 March 1999 and was also modified on 23 November 2017 to include also investment arbitration in its scope of application. According to these rules, and this is its first originality, the CCJA in its jurisdictional function is the exclusive state court to grant exequatur to the CCJA arbitration award, which is the president of the CCJA or a judge member of the court delegated by the president. And the CCJA in its jurisdictional function has also exclusive jurisdiction to examine the request aiming at the setting aside of the CCJA arbitral award. And I must stress with insistence that for the time being, the CCJA is the unique organ in the world with this twofold function, that is a jurisdictional court, Supreme Court for the contracting state, and at the same time, an international arbitration center. This is its first originality. Another important originality is the communatory character of the CCJA exequatur, which means that when the exequatur granted to the CCJA award by the president of the CCJA or by the judge he has delegated, has the effect to make the award enforceable in all the OHADA contracting states. So this is what I think I had to say to introduce the subject. This is a general presentation of the OHADA arbitration system. I remain available for question if need be. Thank you, Sylvie.
Thank you so much, Dr. Ken Pak. And for the little story, I have to say, I didn't say it, that Dr. Ken Pak is one of these people who take me by hand and said, oh, you are a lady, an African, and you have to really be interested in arbitration. So I started my arbitration journey with him. And I'm really thankful because he was like a visionary. It was like 20 years ago. That would give you an appreciation of my age maybe, but I'm really grateful to have met him in my journey, and is for me as a father. And as I was saying, we are really lucky to have him with us today, because you will maybe say it during our conversation. What he did, it was to really set this scene, because as I was saying in my introduction, many of us have heard about OHADA, but I was seeing in the chat that some of was asking, what is the acronym of OHADA about? And I explained very well what is OHADA. Is the Organization for the Harmonization of Business Law in Africa. So to really summarize what he said, OHADA is about harmonizing a business rule in 17 African countries. And is mentioned these countries. I won't go into this country anymore, but what he said also was to remind that OHADA arbitration is about two governing sets of rules. That's what you have to get also in mind. We have the arbitration rules coming from the Uniform Act, which is like the model law within the OHADA states. And besides, you have the arbitration rule under the CCJA. And he explained that the CCJA, the particularity and the specificity of the CCJA is that is at the one end is the Supreme Court of OHADA arbitration states. That means that when we have to deal with a business disputes at the supreme level, all the OHADA members will go to CCJA, which is located in Abidjan. But besides, the CCJA is also an arbitration center. This is really something very specific that you have also to bear in mind. Is a body with two roles. One is to be the Supreme Court, and we have judges, and within the CCJA, we have an arbitration center. And this is a very good transition. I would like you to have this in mind for our the following of our webinar, and we will now get into the CCJA, because we are dealing with OHADA, but we are also dealing specifically with OHADA arbitration. And I would like now to introduce my second panelist, who is Dr. Petronil Mafoho-Bujeka. The good thing and the really, as I was saying, we are lucky to have a stellar panel of practitioners. The good thing we have today is that Dr. Mafoho is one of these innovation, if I may say so, that we really registered this last month within the CCJA arbitration system. She is one of the member of the committee of the monitoring of procedures within the CCJA Arbitration Center. Why this committee was welcome? Because for many years, the people who was monitoring procedures before OHADA Arbitration Center were judges. And this was something which was really bad seen within the OHADA community. So last year, I think 2 years now, OHADA decided to set up this committee, and we are lucky to have Petronil, who will now really focus our purpose on the key features of the CCJA arbitration system, and really present the innovation which have been observed during these 2 years. Petronil, without a further process and delay, I will let you present the CCJA key feature in 10 minutes because we are running out of time. Thank you. And we want to leave time for discussion. So you have 10 minutes to let us know about CCJA arbitration system.
Thank you so much, Dr. First of all, I want to greet all of you. I'm very glad and very honored to be a part of this panel today, because I should say that all of you, you are my elders, you are my teachers, and past few months ago, I couldn't even dream of having a speaking among you. So thank you so much for that. You also said it, Dr. Sylvie Beboyi, the General Secretary of the Center, get a held up and couldn't be there today. He apologizes for that and send him his greetings. Okay. I think I also want to thank the Ciarb to inviting us on this discussion today. It is a very important topic, I think, and I'm sure that all the solutions or all the ideas which will rise at the end of this webinar will surely lead to constructing bridges between our Nigerian colleagues and the OHADA system. So, as Dr. Kenfax has already drawn the framework, let us go straight to the point. I have made a PowerPoint presentation. Can I share my screen with you, please? Not.
I think that will not be possible because I don't have the main or the key on the webinar. Maybe you can just share the key features. That will be easier. I don't know if we can, and we are running out of time as the webinar is scheduled for 19 minutes. So I will ask the organizer, but you can start. Please.
All right. Okay. Let us go straight to the point. Okay. The innovations in CCJA arbitration. As Dr. Kenfax said, the OHADA arbitration system is dual. The duality means that the OHADA arbitration system has a court of justice and an arbitration center working together. The main innovation is the separation between the court and the arbitration center. Because for a long time, the CCJA OHADA Arbitration Center consisted of a team of 2 people, the General Secretary and its assistant. And due to its integration into the court, the rules provided that the court would administer arbitration proceedings with the assistance of the General Secretary. So that was a subject of discussion and criticism and maybe some interest conflicts, because in the arbitration proceeding, the General Secretary was just a sort of link between the parties and the arbitral tribunal. And the administration of proceedings, the question like appointment of arbitrators, procedural issues, preliminary review of awards was carried out by judges sitting in a restricted panel. So now a space has been allocated solely to the arbitration center and its activities. That is the first point. The other point is that a procedures monitoring committee has been created, made up of arbitration specialists to administer arbitration proceeding under the CCJA Arbitration Center. The Arbitration Center team now consists of the General Secretary, the Procedure Monitoring Committee, and assistant. The committee is supposed to be composed of at least 5 members, but for now we are just 2. So when we are sitting talking about arbitral procedures, we are 3, the General Secretary and my other colleagues, so we are 3 to administer arbitration proceedings now, for now. The committee performs the role previously assigned to the judges sitting in a small panel. And the Procedure Monitoring Committee of the CCJA Arbitration Center now plays a central and strategic role in the administration of OHADA arbitrations. That is the main point to know. So no more interest conflict, no more judges sitting in a panel talking about arbitration procedures. That is the major reform in the arbitral governance system of OHADA. It's a very important, that is a very, very important point. So what now are the functions of the Procedures Monitoring Committee? The main functions are exclusive administration of arbitration proceedings on behalf of the CCJA as of July 1st, 2025. So
you have 3 minutes left, Francophone.
3 minutes, just 3 minutes.
Yes.
Okay. And the innovation brought about this reform is the modernization of the international arbitration of CCJA, because now we have a management of procedural incident, including request of recusal and so on and so forth, ruling only by the procedure monitoring committees and not more and no more by judges. What can I say? And the creation of the procedure monitoring committee has really a strategic impact of in the case of increasing of and strengthening the credibility of the CCJA Arbitration Center. That's really improved the quality of the arbitration service with optimized processing times. And that also increased the attractiveness for investors and legal practitioners. So that's what I can firstly say about the CCJA Arbitration Center key features. Thank you for your kind attention.
Thank you so much. Thank you so much, Dr. Mafolho. And just to summarize what you were saying and to remind our following participants of what we are discussing, what Petronet did was really to introduce some key features of CCJA arbitration. As you have in mind, we have 2 governing bodies of rules, the rules within the OHADA Arbitration Act, which is the model law, and a specific arbitration system. And maybe we will clarify in the discussion why the CCJA arbitration system was set up apart from the OHADA Uniform Act. That will be maybe one of the clarification also we will be doing during the discussion. And what Petronil was also saying is very important, and I want to remind that, is that before the innovation we were just mentioning, there was a selected committee of judges who was monitoring the proceedings. Now we have this committee, which has been set up like the ICC secretariat, if you want, to monitoring the proceedings. So the judges are not more included in arbitration within the CCJA, because that was something who was really bad seen. Even though it was a selected committee, people thought that judges was included. There is a mic. Please, if you can, yes, if you can close your mic. There is a mic who is doing very bad noise, and people are complaining about it. So this monitoring committee is a very central innovation for the CCJ arbitration system. So thank you very much, Dr. Maforo, for your presentation, your clarification. And without a delay, I will introduce our third panelist, and is also one of these people who don't need introduction at all. Is my elder brother, is a barrister, renowned barrister, mediator in England, but is also, because there is a question on the chat. Someone just asked, how can Nigeria benefit from the OHADA system without being a party of a contracting party to OHADA? I think Julius will have to answer to that question, because it will really present the opportunity. How can a Nigerian, I don't know, a trade Nigerian can maybe do deal with transaction with a Benin trader, or an Ivorian can do transaction with a Ghanaian? How can we benefit from each other, even though these countries are not part of the OHADA system? So Julius, your task now is to try to clarify. And also, Julius is a good example that OHADA is not about French-speaking countries. OHADA is about international rules, and that's what Dr. Kenfak was saying. When you take the OHADA Arbitration Act, is based on UNCITRAL rules. When you take the CCJ arbitration, you can see that there are international principles there. So the role of Julius is really large and double, to explain what opportunities can people from Nigeria, from Anglophone country get by knowing OHADA, and also to explain that OHADA is not just about French-speaking people. So Julius, in 10 minutes, and I know that you know very well how to spread things, you will have to explain us what are the opportunities we have to know better about the OHADA and OHADA arbitration for traders, for all these people who are doing business within Africa, even though they are not part of OHADA contracting states for now. Julius, the floor is yours.
All right, thank you so much, Dr. Bibo. You've made it so easy for me, because you've said almost everything that I should be saying. That is good. But I just want to quickly say that the marketing and selling of goods and services across countries in Africa is not a new phenomenon. In fact, it is expanding. And we all know that when trade and commerce expand, disputes follow. In Africa, OHADA is one of a few international organizations that try to facilitate trade, but also have created mechanisms for dispute resolution. And the OHADA arbitration that you've heard about comes with so much and so many benefits and so much style in terms of aiding parties.
Sorry, Julius. Let me just, can you please close your mic, please? There is a mic who is doing a very bad noise and we can't hear the participant very well. Please, this is for participant. Can you close your mic, please, to make it clear when we are talking, please? Really. Sorry to interrupt you, Julius.
Yes, sorry. So I was just saying that they OHADA, like the African Continental Free Trade Agreement and so on, they provide mechanisms for dispute resolution. And the OHADA, especially as has been explained by Dr. Kenfak and Dr. Mafoho and Dr. Beboi, for that matter, from what they've said so far, you can deduce the benefits, the advantages of using OHADA arbitration, because when we talk about flexibility in arbitration, you can't get better than what OHADA provides. But I'll just go very quickly at some history as to why the whole idea of OHADA came about and why a dispute resolution mechanism of that magnitude was needed. Of course, after the independence, you know that countries continue to trade, but the mixture of different laws, different rules, and so on was really, really confusing. So to make matters easy, the whole idea of OHADA came to fruition. And it is not only limited to French-speaking countries. It is true that at the moment, predominantly French-speaking countries, but any country can become a member. So long as you're a member, you're an African country, you could become a member. The languages used for OHADA include English, Spanish, Portuguese, French. So you choose. Dr. Mafoho has just spoken in French. Dr. Beboi, in English. Dr. Beboi is speaking in English. Dr. Kenfak speaking in English as well. So Cameroon, as a miniature of Africa, we have those two languages and we use them, and we all, whether French speaking or English speaking, we submit to OHADA arbitration. So giving that background, why we have this, the CCJA, when it was created, the very, very beginning, the first case it did, I mean, I know that case is a very popular one, the Makaki case versus Jean-Pierre May. You could see how it actually did a fantastic job about competence. It dealt with several issues, and impeccable outcome was felt. It is true that sometime down the line, we had the unfortunate situation of Getma, but it also taught us a lesson that we should reform things. And in 2017, you could see what came out of the Arbitration Act, the new Uniform Act, and so on. So it is impeccable, very good. And talking about that, I should quickly remind that although Getma had they hit the headlines for the wrong reason, and for so long time, there are other irregularities in other jurisdictions, in other well-known institutions across the world that we know, but it has not reduced the amount of disputes that go there. And I say this with some little sadness, in the sense that while other irregularities go on in other places, and we could quickly, they're not hard to find. If you turn left, right, center, you just find the case of Port Autonome, which is not, which in my judgment is more serious in terms of irregularity than the Getma case. And I say this because we find a situation where disputes, African disputes, even disputes that concern two African parties, and the subject matter of the dispute is in Africa, and everything about that dispute is in Africa, they still find their way in Paris, in London, in Geneva, and across the world. But I think what we are saying here is that Nigeria and Cameroon, for example, they have they're oil-producing countries in Africa. They're neighbors. Why would it not be possible for them to engage or submit to OHADA? Ghana and Cote d'Ivoire, one of the leading cocoa-producing countries in Africa, why would they not submit to OHADA? Because of course, OHADA provides the possibility to do your case in English or in French, anyone that the language that most is most convenient for you. So, giving all these things, I know the time is limited. Giving all these benefits of OHADA, it is our plea that we think about making use of OHADA. It will cut the cost of trying and flying very far away with all the witnesses, with all the evidence and so on, when you can do things in the neighbor's house or next to the neighbor. And of course, when I say in the neighbor's house, I must insist that it provides neutrality. The fact that it may be sitting in an arbitration may be sitting in Abidjan or in Cameroon or in Nigeria, it doesn't matter. What matters is the law that is being applied and what parties have chosen as their seat of arbitration, and that in the event where an award is obtained, then enforcement is as slick as anything. You know, you enforce the award in any contracting state, and that award will be considered as a judgment, the final judgment of that country. So it has the same flair as the New York Convention, the 1958 Convention of Recognition and Enforcement of Arbitral Awards. So it has all these benefits. And I can tell you, whether we like it, we are all submitting to arbitration in one way or another, because obviously cross-border disputes in Africa, we can't talk about litigation because it is just not going to happen. As far as I know, there's no African country that is a member of the Hague Convention on Recognition and Enforcement of Foreign Judgments. No, as any of them, a member of the Hague Convention on the choice of law. So we are stuck with arbitration. But if we want to support investment, we want to support growth in our region, we should try to resolve as many of these disputes within the continent as possible. Because it is sad when we see the flight of disputes, and I just gave the sad example, and there are quite a long list of them if we want to go through them, where the parties are Africans. The subject matter of the dispute is in Africa. The witnesses are in Africa. Evidence is in Africa, but they find themselves in Paris, they find themselves in London, they find themselves in Geneva trying to resolve this. You can still sit in Africa within the OHADA rules and laws, and you can still bring your arbitrator, whoever. I'm not saying that a non-African cannot be an arbitrator. No, far away from that. You can choose your arbitrator from everywhere, but let the seat be in Africa. Let the laws be that of OHADA. All of us arbitrating in other parts of the world, we are doing that not because we were born there. It is because we've learned the laws and the rules, and so we can apply it. So I think any arbitrator, wherever they're born or wherever they reside, they should also be able to do things according to the rules and regulation of the OHADA arbitration system. And I know that I have spoken about the GEDMA case, and I did that intentionally, knowing that I think one of the reasons for the low take-up of OHADA arbitration today is because the spin that was given to that case across the world is saddening, because it was made it was made a very big thing across the world. But as I said, when I think about, again, the recent case of Port Autonome, which to my judgment is worse in terms of irregularity than the GEDMA case, that hasn't reduced the amount of arbitration still going to these institutions. So I will stop at the moment, just I'll stop for now, and maybe I'll answer questions if they become available.
Sylvie, may I add some few words to what Julius has said concerning, for example, the nationality of the parties in OHADA arbitration?
Of course.
Thank you. To add to what Julius has just said so brilliantly, there is no need for the parties to belong to one OHADA contracting parties to be involved in OHADA arbitration. If, in this regard, I must say that to be applied, the Uniform Act can be applied, and it remains an option, can be applied only when the seat of the arbitral tribunal is located within the OHADA territory. This is for the implementation of the Uniform Act on Arbitration. And concerning the CCJA arbitration system, the CCJA rules will be applied when the dispute is a contractual dispute with a link with the OHADA territory, just because one of the party is from the OHADA contracting state, or when the contract is to be implemented partially or totally in the OHADA contracting state. You see, there is no nationality related to the person, to the parties that are involved in OHADA arbitration. This is one thing. The second thing is, Julius has mentioned the JEDMA cases. And during the 2017 modification, this JEDMA situation was taken into consideration. What is at stake here? What is at stake? The problem is there is a scale of fees that is in the annex of the arbitration rules, of the CCJA arbitration rules. And according to the rules here, as in other institutional center of arbitration, when there is a scale of fees, there is no reason why an agreement between the parties and the arbitrator should take place, particularly without the agreement of the arbitration center. That is what happened to the JEDMA cases. And now, if such a situation arises, as from now, the solution or the sanction will no more be the setting aside of the award, because such an agreement is not one of the reasons for the setting aside of the award. This is to be, it's very important to clarify it. It happened in the past, but now during the 2017 modification, this has been addressed, and it is clearly stated that as from now, if there is an agreement between the arbitrators and the parties, contrary to what the scale of fees and the rules of arbitration say, the sanction will not be the setting aside of the award. It's important to stress it. Thank you.
Thank you so much, Dr. Kenfat, for this important clarification. Just to summarize what Julius was saying, and to respond to one of the questions, and maybe to summarize what you all your presentation. What is the benefit? What is the benefit to for a country like Nigeria to be a part of OHADA? First, you will be in a global, a regional system. That is one of the benefits I can see from now. And OHADA is one of these good example we are looking, because if we are if we think about the trade, the African trade agreement, OHADA is now the example that we can apply rules, common rules together. Because if you go to Côte d'Ivoire, you go to Mali, you go to Senegal, you go to Gabon or Cameroon, you have the same business rules, and that is a very important thing. That is one of the benefits. The second benefit we may see with the OHADA and the OHADA arbitration system is that I'm a business lawyer. I'm located in Benin and I'm doing business in Nigeria. Julius stressed that why should I put a draft an arbitration agreement or send my disputes to Paris, if any? I can just draft my contract with an agreement setting the CCJA arbitration. Why? Because if I have an award coming from that dispute, that award can be enforced in 17 African countries. That means that if the person has goods in some of these countries, I will enforce them easily than having an award who will be pronounced in Paris and giving it back in one of these countries. So that are really good benefits. And maybe the third benefit, and I would like maybe Julius also to clarify that point, is about, I just talked about it, but enforcement today. What you have to know is that the OHADA, as mentioned by Petronel, Dr. Kenfak, is a dual system. It means that we have also, for enforcement, we have all OHADA countries are members of the New York Convention. So for enforcement, if you have a dispute out of one of the arbitral institution within OHADA and you want to enforce, you are in Nigeria, you are in Ghana, and you want to enforce within OHADA, you can benefit from the New York Convention. So there are a lot of benefits, and you can see that our panel is a panel made of practitioners practicing both in French and English, practicing both in common and civil law system. So by coming to the OHADA and by practicing arbitration OHADA in your contract, by inserting it in your contract, it will also open your mind. And maybe I will finish with that. Why should you go to London, where you have nearby Cameroonian who can explain to you rules of civil law, who can really be there for your dispute where you have a civil law which is involved? So it's a great benefit that we really put hands together and see our neighbors rather than going so far. That does not mean that we are close to others. Really, this is not the speech we are having here. We are not close to others. What we want to stress is that we have within us this system that we can exploit rather than going so far when we can solve these disputes among us. And now I will open the floor for questions. And one of the questions I have in the chat, and I will leave it maybe to Dr. Kenfak, is the question is, does the Uniform Act provide for the appointment of emergency arbitrators?
To answer that question, there is no such provision in the Uniform Act, but which does not mean that it is not possible. There is no provision simply means that you can ask and it is possible to do that, you see. And in this regard, there is a competent concurrent, a concurrent competence to both the arbitrator and the state court when you are looking for provisionary measures. When the arbitral tribunal is not yet put in place, if you are looking for such measures, it's the exclusive competence of the state courts. But when the arbitral tribunal is already in function, you have the choice between going to the state court or to the arbitrators, but taking into consideration that for some specific measure, it might be more interesting to go to the state court, even though the arbitral tribunal is already in function, because due to the nature of these measures, it might be more indicated due to the nature, to the binding nature of the decision issued by the state judge. It might be more interesting to go to the state judge looking for this measure. Whereas if you have the measure granted by an interim award, if it is not spontaneously implemented by the party, you will be obliged to come back to the state court to look for exequatur. That might be a lot of time, you see. That's why I say, depending on the nature of the measure expected or zooked, it might be more interesting to go to the state court to seek those measures, even though the arbitral tribunal is already in function. I hope I'm understanding. I'm answering to that question.
Thank you. Thank you, Dr. Ken Faki. I think it's clear. There are not specific provision on emergency arbitration within the OHADA system, but nothing prevent us for having emergency arbitration within that system. Another question who would be with for Julius is a very interesting question. Is considering the growing importance of the OHADA region for international trade, what specific procedural innovation or unique features within the OHADA arbitration system should a Ciarb member who is primarily familiar with arbitral or ICC rules be most aware of to effectively represent clients and leverage opportunities in this jurisdiction? What are the key features, Julius, procedural innovation you can present for someone who has never used the OHADA rules and who would like maybe to ask to bring that to his clients?
Well, I think the first thing I would say is that we just mentioned about the Uniform Act of 2017, and I said that that was highly inspired by the UNCITRAL rules. UNCITRAL rules is generally, the model law. It was highly inspired by the model law. And in terms of the rules, these rules are also generally inspired by the ICC rules, the London Court of International Arbitration rules, the UNCITRAL rules, and the Swiss. In fact, it takes a combination of all the best practices. That is why I generally would say it's one of the best, because it has actually considered all the top rules. So to start with, you will not be straying further from what you already know if you are if you are already a practitioner. But the one thing I would say is that it generally never hurts. The rules and the procedures, everything they set out. The OHADA has one of, I must say, user-friendly websites that sets out these rules and procedures in very fine detail in both French and in English, which I think could be of use to anyone who hasn't done that before. But again, you see that you have people like the people on the panel here. I've known them for very long time now, since I was a boy, and they're all very friendly people, always happy to assist and willing to willing to support if anybody was in need. it may not be, I mean, it may not be straight to your question, but it's generally not easy to just talk about general provision without having case specific. But as I say, the rules are inspired by the ICC rules, the UNCITRAL rules, the London Court of Appeal. So it's nothing which, you know.
You're getting, your network is not working. Okay. There is a problem with your network, Julius. We just lost you
My
for
network?
like 30 seconds.
Sylvie, Sylvie, may I add something to what Julius has said? Are you getting me?
She's not getting you.
Can you get me?
Me, I can get you, but I think Dr. Sylvie is not getting you.
I can get you. I don't know where I ended, where you got, where you heard till, but fine.
Is Sylvie still around? My friend request, are you, yeah, are you getting her, Sylvie?
Yes, yes.
So, if Julius has stopped speaking, may I add some few words?
Yes,
yes,
can.
of course.
Advantages to rely either on the Uniform Act on arbitration or on the CCJA rules of arbitration. As to the Uniform Act on arbitration, you see, if we have to compare the seeking of exequatur in the Uniform Act system and on the New York Convention system. The New York Convention system foresees an motion on notice proceeding for the research of exequatur, whereas the Uniform Act on arbitration foresees an ex parte motion, you see, which means that the adversarial principle or the right of defenses are less protected within the context of the Uniform Act, because when you obtain exequatur, the rules is that this decision cannot give right to any recourse. But if you want to block the implementation of the award, you just introduce a recourse for the setting aside of the award, which is more protective than making a recourse against the exequatur. You see, this is a great advantage. This motion ex parte proceeding for the seeking of the award. And as to the CCJA rules of arbitration now, one important thing, if we have a comparison to make with the ICSID, and you know very well about it because your thesis was on this subject, the very importance of these CCJA rules, the communitary nature of the character of the exequatur granted by the president of the CCJA or by the judge he has delegated. This communitary nature has the effect that when it is granted, it makes the CCJA award enforceable in all the 17 current contracting states of OHADA, whereas if we have to compare it, for example, with the ICSID system, the exequatur will granted in a country will make the ICSID award enforceable only in the country where the exequatur has been granted, whereas you see the gain of term with the CCJA system. So I think these are advantages that are not common everywhere, and that can draw the attention and stress the importance of OHADA arbitration. This is some few words I wanted to add to what Julius has so brilliantly said.
Thank you so much, Dr. Kenfax. So our friend has now some procedural advantages of advising his clients to have an agreement under OHADA, whether it can be under the Uniform Arbitration Act or the CCJ arbitration rule, with that very big advantage you just traced, that you have the enforceability of the arbitration award possible in 17 African states. I put my hands in fire if you can present to us a system who has this great advantage. And I was saying that if you are a businessman in Nigeria and you are having a business with a Benin businessman, you better have an arbitration agreement and design the CCJ arbitration center, because you can choose your arbitrators and have this arbitration award who is enforceable in 17 African countries. I have a question now for Petronil. I will take 3 other questions in the chat and we'll resume. What is the role, what do national courts and arbitration center play in ensuring OHADA's effectiveness? You are now at the CCJ. What is the role the CCJ, you see the CCJ playing in ensuring this effectiveness of OHADA within the arbitration center you are now working in?
Okay, thank you for giving me the floor. The first role I can see is to support the work of arbitrators. How do the judges support the work of the arbitrators? When the seat of arbitration is in the field of an precise or other country, the judges come to support the role of the arbitrators for taking, we are talking about, how can I say it? In French, we call it mesures conservatoires. When
conservatory measures.
Provisional measures.
Yes. In some cases, the role to take conservatory measures is still the part of the judges. That is the first point. The other point is the control of the award. Control of the award. When we have an award and that which is not accepted by all the parties, maybe because of a procedural scene, the judges has the role to control the award after it is rendered. So that is what I can say about supporting the role of arbitrators and making the OHADA Arbitration Act effective.
Okay. Thank you so much. I will maybe open it now to Dr. Kanfak, because there is a double question, because as we see, we saw is a senior magistrate, and I want him really maybe now to clarify the role of national courts in the implementation of the OHADA arbitration system. And there is a question, but maybe it's a clarification rather than a question, because someone just asked what is in event there is a conflict between the decision of the Common Court of Justice and Arbitration Center, with decision will prevail. But I think this is more a need for clarification than a question. So first, Dr. Kempak, what is the role of the national court? What role the national court play today for the implementation of OHADA arbitration? And can you better explain the double role of CCJA as the Common Court of Justice of OHADA arbitration states and its role as an arbitration center?
Okay, thank you. First of all, as we have already said, the Uniform Act on Arbitration is the arbitration rule for each OHADA contracting state, which means, and we have also said that the Uniform Act on Arbitration make it clear that ad hoc arbitration and institutional arbitration coexist in the OHADA territory. And in this regard, in a case of an ad hoc arbitration, the state court will assist, because in the spirit of the OHADA legislator, arbitration and state justice are complementary, in the sense that if in an ad hoc arbitration case, the one of the party prevents from designating its arbitrator in a deadline agreed by the party or precised in the Uniform Act, the most diligent party will have to go to the state court, which rules is to appoint an arbitrator in a certain deadline. The Uniform Act says 15 days from its seizures, and in the countries and in the OHADA countries where there is a more brief delay, that delay will be, the judge will comply with that delay. And what important thing, and it gave me the opportunity.
Network again. Okay, maybe I will try to summarize what Dr. Kenfak was saying. Just to clarify that question, you have to know that there is different role. The role of the Common Court as the Supreme Court is different from the role of the CCJA when is taking decision concerning arbitration. So there will not be a conflict within the CCJA as a Supreme Court, because it's a different role, and the CCJA when is stating on annulment and also granting exequatur to the award rendered within its system. That is really to summarize what Dr. Kenfak was saying. And there was a question again about OHADA arbitration. OHADA acronym. The person was saying he didn't want to have the meaning of the acronym, but he wanted to know what is OHADA about. And I said it when I was introducing. OHADA is about harmonizing rules of business law. So this is the main main feature you have to have in mind when we talk about OHADA, is that you have the same business rules in 17 countries. If you go to Cameroon, you will have the same rule applying in Cameroon, Benin, Cote d'Ivoire, Mali, Senegal. So they are not different. And I maybe have a last question, and this will be for Dr. Kenfak, because this question concerns the treaty. He knows very well. I have the answer, but I'll leave it for you, Dr. Kenfak, maybe to resume. In 1 minute, is there a room for West African English-speaking country to join OHADA treaty? You are on mute. We can't hear you. So maybe while waiting for Dr.
The
Kenfak,
answer is yes. The answer is yes. You see, Cameroon is a bilingual country with French and English as official language. And because of Cameroon, English is one of the 4 speaking language, which shows that English-speaking country can easily join OHADA. It's very simple. And now we have some of them knocking at the door of OHADA. So it's possible for those people to join OHADA.
Thank you so much, Dr. Kenfak. I think to really summarize on this, OHADA is open to all African country members of the African Union African Union. So it's open to them, and this is really clear in the OHADA treaty. And our wish is to have, because the person was saying that can we have a uniform system of arbitration in African continent? I think we can get there, and that's why I was saying that OHADA is a good example because the treaty is now 30 years has now 30 years, and is a testimony, is a very big testimony that in Africa we can have a uniform system because we applying OHADA arbitration. OHADA is in place since 30 years, and we can really get there to have a uniform system in Africa. And I think the African Trade Agreement can give us this opportunity to really enlarge the scope of our arbitration system within Africa. With this, I would like now to really thank my stellar panel. I'm really happy that maybe today we set the scene, and we can maybe have another webinar with a particular focus on the proceedings or on the procedure, because what we wanted to do today was really to introduce you within OHADA and the OHADA arbitration system. And I want you to go and have it in mind that this is a double system with a uniform act, which is like the modern law within the OHADA member states, and a specific arbitration system. And that there are big benefits to advise your clients when you have a business, you're doing business within the region, to have OHADA arbitration agreement rather than having orders from a different region. With that, I will resume and give the floor to our the Ciarb branch who is hosting us today. I don't know if Dr. Akbelusi is there, or my elder sister Solar, to resume and summarize the webinar. There is silence in the other parts. So I suppose that Solar.
All right, Sylvie, thank you very much on behalf of the Ciarb branch. I want to appreciate all eminent speakers. It's been a wonderful webinar today, and we want to appreciate Dr. Gaston, Julius, and the Water Center for Petronil, and Madam Sylvie for putting so much effort. We hope for more collaboration between France and the Francophone countries and Anglophone, more opportunity for us, especially on the different protocols that we're signing. And I'm hoping that everybody also going to register for French classes, because our guests today have been very, very kind to speak in English, which is not native to them. So we appreciate them for that generosity, and we hope that we also be able to have more opportunities to work with this organization. So the link for the MBA CLE is in the chat. Please use it to get your CLE points, and kindly don't share it with anybody who hasn't attended this webinar. Once again, we thank all of you, and we thank our panelists. I hope to see you next month, that Friday, for the next webinar. Have a great day.
Thank you for hosting us. Thank you. Have a good day. Bye-bye.